Have you ever wondered what would happen to your kids if you were no longer around to raise them? It's a tough thought, but planning for it is one of the most important things you can do as a parent. Today, I'm giving you the exact legal roadmap to appoint a guardian, so you can make sure your wishes are honored and your family avoids costly, heartbreaking court battles. So, why does this matter so much? If you don't legally name a guardian, the decision is left up to a court. A judge who doesn't know you or your children will decide who raises them. This could be a distant relative you barely speak to, or in the worst-case scenario, the state foster care system. Your children would be facing the unimaginable loss of their parents, compounded by the uncertainty and instability of a court-appointed arrangement. Proper legal documentation isn't just paperwork. It's your voice, speaking for your children's future when you can't. It ensures the person you trust most is put in charge, quickly, and without a fight, allowing your kids to find stability and love during an incredibly difficult time. Let's break down the essential legal steps to make this happen. First, and most importantly, you need to choose the guardian. This isn't a decision to take lightly. Think about who shares your values, your parenting style, and has the emotional and financial stability to take on this role. Consider their age, their health, and where they live. Would your kids have to move and change schools? It's also crucial to choose not just one primary guardian, but at least one alternate or backup guardian. Life is unpredictable, and your first choice might be unable to serve when the time comes. Having a backup plan ensures there's always someone you've personally chosen ready to step in. Once you've made your choice, the next step is to make it legal. The most common way to do this is by drafting a will. Your will is a legally binding document where you can explicitly state who you want to be the guardian of your minor children. The language needs to be crystal clear. For example, I appoint Jane Doe as the guardian of my minor children. You would also include the name of your alternate guardian in a separate clause, like, if Jane Doe is unable or unwilling to serve, I appoint John Smith as the alternate guardian. If you already have a will, you might be able to add this through a codicil or a separate guardian designation form, depending on your state's laws. The key is to get it in writing in a formal, legal document. Now, here is a step that many people overlook, but is incredibly valuable: creating a letter of intent. While your will legally appoints the guardian, the letter of intent guides them on how you want your children to be raised. This isn't a legally binding document, but it's your personal roadmap for the guardian. You can detail your preferences on everything, schooling public or private. Your thoughts on religion and spiritual upbringing. Your wishes for their medical care, or what extracurricular activities you'd want them to pursue. This letter helps your chosen guardian understand your hopes and dreams for your children, ensuring your values continue to shape their lives. It fills in the gaps that a formal legal document can't cover. After you've drafted your will and your letter of intent, the next step is execution. This means you need to sign the documents correctly to make them legally valid. For a will, this almost always requires you to sign it in the presence of witnesses, usually to people who are not beneficiaries in your will. They'll also sign the document, attesting that they saw you sign it. In many states, it's also a good idea to have the will notarized by getting a self-proving affidavit. This simplifies the court process later on because it provides an extra layer of validation that you signed the will correctly and willingly. Don't skip this step. An improperly executed will can be challenged and even thrown out by a court. Once the ink is dry, your job isn't quite done. You must have a serious conversation with the people you've chosen as guardians. Sit down with them, explain why you chose them, and ask if they are truly willing and able to accept this profound responsibility. This conversation is not optional. The last thing you want is for them to be caught by surprise and potentially decline the role, sending the decision right back to the courts. After they've agreed, give them copies of the relevant documents. This includes the will, the letter of intent, and a folder with other crucial information like your children's birth certificates, social security numbers, and details on any life insurance policies or financial accounts you've set up for them. This preparedness is a gift to both your guardian and your children. Finally, you need to update all your other relevant records. Life changes, and your documents need to keep up. Go through your life insurance policies and retirement accounts and make sure the beneficiary designations are current. Check your healthcare proxies and advance directives. You should also update your children's school and doctor's office with the guardian's contact information as an emergency contact. This creates a consistent and clear line of authority, making it easier for your guardian to step in immediately if needed, without facing administrative hurdles. Now, let's talk about the common mistakes people make, so you can avoid them. The biggest mistake is not discussing the choice with the prospective guardian. Imagine their shock and pressure if they find out they've been named guardian only after you're gone. They might feel they have no choice but to say no, which completely undoes all your careful planning. Always have that open and honest conversation first. Another huge error is using vague language in your will. Simply writing "I want someone I trust to raise my kids" is legally useless. A court can't interpret that. You must name a specific person. Be clear, be direct, and use their full legal name. Forgetting to name an alternate guardian is another common pitfall. What if your primary choice passes away before you, or their life circumstances change and they can no longer serve? Without an alternate named in your will, the decision defaults back to the court system. Your backup plan is just as important as your primary one. And finally, many people skip the letter of intent. They assume the guardian will just know what to do. But remember, without your guidance, the court and the guardian will have to rely on a vague best interests of the child standard, which might look very different from what you would have wanted. Your letter of intent is your chance to guide their upbringing from the heart. Taking these steps gives you peace of mind, knowing that you've done everything in your power to protect your children's future and honor your wishes. Thank you so much for watching. If you found this guide helpful, please subscribe for more essential family law tips. And I want to hear from you. Leave a comment below with the biggest question you have about guardianship. I'll do my best to answer it in a future video. See you next time.